Okay, first matter up this morning, Bramer versus Bramer.
Ready, Your Honor.
Oh, Your Honor, I'm sorry. I thought we could not appear by person.
You can actually, but it doesn't,
The rules just changed, Melissa.
I'm fine either way.
Oh, okay. I'm so
it
sorry.
may
I would
be-
have been down there.
Saved you a trip.
No, thank you.
Okay, counsel, state your appearances, please.
Ronald Fabian on behalf of the plaintiff.
Your Honor, Melissa Lucky on behalf of Artie Bremer, who's present seated to my right in my office.
Okay, and I don't see Ms. Bremer. Were you expecting her?
We're expecting her to be on the Zoom.
Let me see if there's a name here that I don't. What's your first name?
Her first name is Sean, S-H-A-U-N.
I've got a Sean Makia.
That's her.
Oh, okay.
That's her maiden name. Sorry. There she is.
Yep.
Sean?
The audio is not connected yet. Okay, Ms. Makia, can you hear me?
Yes, I can.
Okay, so this is the defendant's motion, correct?
There are two motions.
Two motions?
Ours was the initial motion. It was to have the plaintiff held in contempt for not following the court's order and to impose sanctions as recommended by the parenting time coordinator. They then filed a responsive motion to terminate the role of the parenting time coordinator.
Okay. For some reason, only one of those showed up on my docket, but that's fine. Ms. Lecky, are you prepared to address both motions this morning?
Yes, Your Honor.
Okay, go ahead, Mr. Fabian.
Well, our first motion is the one that was filed first, and then we adjourned that to give Ms. Lecky a chance to look at it and also file her own motion. So the fact that it wasn't, the fact that you don't have it sort of disturbs me, but there you go.
I didn't say I didn't have it.
Oh, okay.
What I said was it wasn't on the docket.
Okay. About a year, slightly more than a year ago, we all agreed that the party should go to see a parenting time coordinator, Stephen Reed in Ann Arbor. It took a while to get the order out because I think Mr. Bremer was initially sort of reluctant to do that after all. But we did. He met with Mr. Reed. They signed all the necessary empowering documents. And among Mr. Reed's recommendations were that they see a specialized therapist. And she's both an attorney and a therapist to work out some of their problems. Because their problems, Judge, are myriad, and to someone like you, they're going to seem petty. But they're so disruptive to their lives and the children's lives. So attached to my response, you'll see that I included a letter from the therapist, Carrie Ann Rosenblum, who said, listen, he's just not going to show up. So Mr. Reed put them on basically a behavioral schedule of if you have any complaints about the other person, you have to email him by, I think it's the 15th of each and every month. Dad's never really complied with any of that. Dad refuses to see Ms. Rosenblum. So then Mr. Reed fined him, and he said, listen, if you don't start doing these things, I'm going to fine you. And excuse me, Judge, I'll turn this on. Part of the parenting time arrangement was that he had that power. He also had the power to issue recommendations to you, and if neither party objected within 14 days, those recommendations become the order of the court. So he didn't go crazy. He just said, do this, do that, let's behave, and we get no cooperation at all from the dad. None. Mr. Reed must have found that impressive enough because he issued sanctions against the dad. They've not been complied with. The sanctions are financial. They're not a lot of money, but they're enough to say, hey, will you pay attention to what you're doing? Meanwhile, the father then filed his own motion to dismiss the parenting time coordinator. And what I find interesting in that motion is he doesn't say, listen, I've talked to him and I don't like this or that. It's all these personal attacks on his former wife. She has too many boyfriends. She won't let him go. She can't live without me. The conflict is constant and enormous. And it'll be over something as simple as, can I take the kids an extra half day because my other kids are coming in town, or alternatively, my dad's in Florida, can we leave a few hours early? Nope, nope, no. So the conflict really can't be resolved in a normal courtroom unless you say, here's what you're gonna do, we're not doing this back and forth anymore, here's your schedule with the kids, here's your schedule with the kids, period. But even then, you would say, I need a third party for you guys to communicate. I need a family wizard or whatever. But because both of these parties are fairly empowered people.
Thank you.
Oh, now Melissa's sucking up. But,
I didn't see that as sucking up. I appreciate it.
all right.
I still yell it
Oh my
from my
God,
office to Nancy. I still yell it from my office into the lobby with Nancy when she sees it. I'm sorry.
If I sneeze on the way out of here, Melissa, you better bless me.
If I hear it, I will.
Okay. Judge, you can see Ms. Lecky and I get along extremely well. This isn't attorneys involved here. It's that these people just can't seem to even share the time of day. We put a special person in charge of them. One of the parties is obeying that special person. The other just says, screw you. So I don't know what else to do. These kids are still young, they're still impressionable, and really it boils down to this. If we don't take some corrective measure with the dad, it's going to be Artie's way or the highway, and that's just the case.
Thank you. Ms. Lecky?
Thank you, Your Honor. I would just note, I've been with Mr. Bremer here in my office since about 8 o'clock, and we've been going through text messages. You know, it says in the recommendation, both parties are to communicate via email only. I'm seeing tons of text messages between the parties. They're both violating it, but what was most notable to me was that they are openly exchanging the children. For example, there's something that says AJ wants to come over your house. Is that okay? Yes, he can, but he wants to come back tonight, or Brody doesn't. They're going back and forth and have been exchanging the kids very well. The text messages that I've seen, and they're most in September. There's some in I think July that I had attached. Nope, I didn't attach it, where they're talking about dropping off, can you come here, reminders of appointments, did you cancel this? Yep, so-and-so is missing. I think it was a dentist appointment. So they are communicating. What this comes down to is Mr. Bremer believes that his ex-wife micromanages. And my point of bringing up the boyfriend is not to say, oh, she has all these boyfriends. That's irrelevant. The point of it is, and that what I think testimony would show, is that despite it being a boyfriend, she went to therapy with this boyfriend. She's a therapy craver. She wants to be able to talk and get other parties involved. That's the only reason. Mr. Bremer is the complete opposite. I haven't heard anything that shows that the kids are being harmed. In fact, I think evidence will show that despite living a half mile away from the school, Mom has had AJ tardy at least 3 times, which has resulted in a suspension. Those are the things that are more concerning to me. My client has sat here and he told me since getting this motion, I never said the kids could not go to Ms. Rosenblum. If they feel they need therapy, that's fine. And that's how this all started, if I recall correctly, is one of the children, I believe was AJ, threatened suicide. You know, my client says, no, he hasn't with me, but he has with Mom. There may have been some texts about that. So we erred on the side of caution to get this child help. He's totally fine with them going there. What he disagrees with is my ex-wife continues to try to micromanage, and I don't sit there and complain to the parenting time coordinator, but she does for everything. And I'm going to tell you, one of the things is this tardiness that causes suspension. Another one was, for example, she didn't return and have the book. There's text messages I looked October 7th that Mom talks about, oh, well, AJ forgot his book. Do you want to come get it? Well, that's not a child's responsibility. It is. I mean, as a parent, you teach both, but it's also the parent's responsibility. So, but he didn't contact Mr. Reed. He doesn't do that because he says it will work out. We'll work it out. We'll get on it. We'll take care of it. She wants to go and talk ad nauseum and bring up every single violation in detail. I have a list here of all of her violations, quite frankly. And I asked him, Artie, why didn't you bring the show cause then? He says, I don't know. It will work out. You know, we get through it. It's fine. So that's, and I'm kind of arguing both are my motion too, because they all surround the same issue. We don't think that Mr. Reed is needed or Ms. Rosenblum for the parties. They seem to be communicating well on text message. Quite frankly, I think they both take the easy way, even though if you say do Our Family Wizard, I think they'll both communicate via text message because they just do what's easier. That's these parents. But based on that's basically all I have to say, Your Honor. There are a lot of things that are going on. He doesn't feel the parenting time coordinator is doing or is going to help this. But if the kids need therapy, he's willing to agree to Ms. Rosenblum, I believe that's what we talked about, and have them attend. But he feels it's, in Ms. Rosenblum's words, you are two ships totally apart. And given that, he doesn't think there'll be any headway made. Thank you.
Can I briefly respond?
You may.
It wasn't that the mother chose Ms. Rosenblum for therapy, and she's not a therapy junkie. She's a highly educated business executive who understands that sometimes personal problems need the aid of a third person. It was Mr. Reed who chose Ms. Rosenblum. He has experience with her. I've never met her, but looking at the little bit of work of hers I've seen, she's pretty extraordinary. Mr. Bremer did not object at any point in time to anything that Mr. Reed recommended. He had a certain amount of time to do it. He never objected. Under his parenting time agreement, he's waived those by not complying with the parenting time agreement. Mr. Reed told the mom, go ahead and text him because that's the only way he'll communicate. Again, it's his way or the highway, always. He says, my ex-wife continues to micromanage. He says, well, assume that's true. He won't be managed at all. So what do we have here? We have this constantly. And the way we thought we would resolve it is to put them in a specialist office. Otherwise, we're going to be here every motion day. And this stuff about the books, I don't know where this comes from. Mom is the responsible person. Mom does the homework with the kids, and mom has second copies of all the textbooks. Now, if we're going to get into this kind of minutia, which is not why I filed my motion. I filed my motion simply to say he's not following the court order to which he consented. This is nothing you imposed upon him. He consented to it. He met with Mr. Reed. Mr. Reed made an extensive examination and makes recommendations. He said to both of you, if you cannot behave as adults with each other, behave as an adult with me. Here's your rules. If you have a complaint about the other person, send it to me by the 15th, I think it's the 15th of the month. The other person must respond. If you do not complain by the 15th of the month, those complaints are waived. Because now see what we had here this morning is, oh, remember back in 1984 when this happened, or 1992 when this happened. Mr. Reed, I think his experience is the best leader here, which is if it's important enough to complain about it when it happens, not 6 weeks later, 6 months later, a year later. Mom did not choose Ms. Rosenblum because she's a therapy junkie. Mr. Reed chose her to be a family therapist. Now, what you heard just this morning, this picking and pettiness, it would seem to probably interject a third party. Imagine what this does to two little boys. So, the court order says that he should be sanctioned. And that's all I'm asking for, and that he have a show cause, or you enter a mandamus order, so to speak, or just say, follow the court order. That's it. Thank you, Judge.
Thank you. Well, frankly, this one's pretty easy for me. The parties agreed to a very specific order, and pursuant to that very specific order, the parenting time coordinator has made specific recommendations, and no objections were filed to those recommendations. I am ordering that each of those recommendations be implemented exactly as he recommended, which is exactly what the parties agreed to.
Thank you, Your Honor. That did include Mr. Reed's order that he pays those.
Every single recommendation.
Thank you, Judge. I'll prepare an order.
Your Honor, may I ask one
Yes.
clarifying question?
Of course.
Assuming you can. There was a travel hockey team for the boys, only one attended. Mr. Bremer paid $19.82 to Ms. Bremer, or to Mom, and it needed to be returned, one half of it, and she hasn't. That would be like $991. Can that $500 be taken out of that amount that she owes him back? And the reason why I said if you can is I don't know if this is right for you to decide or if it's been properly noticed on.
I think, well, let me ask, because I didn't go back and review the entire order appointing the parenting time coordinator. Does this fall within his
Yes, it does.
purview?
It does.
Then it needs to be taken to him first. If he believes that indeed that money should be returned, I don't have a problem with the offset,
Okay,
but you got to take the issue to him first.
that's correct.
Thank
Yeah.
you for your time, Your Honor.
And Your
So
Honor,
let me interject here. What I'm hearing from the defendant is, we're getting along. We're doing things well. Why do we need to keep following this process? And I would suggest, well, show your parenting time coordinator that. And if the parties agree that it's not necessary anymore, then you can agree to set it aside. If you don't agree, I'm not changing this order.
Thank you for your time, Your Honor. Thank you, Ms. Leckie.
Thank you.
Can Mr. Fabian add in there? I'm assuming you denied my motion to remove them, so can he just add that in his order?
Yes, please.
Sure, I will.
All right, thanks so much.
Bye-bye.
Thank you.
Good
That
to
concludes our
see you
hearing.
both. Bye-bye.
Thank you, Judge. I'll prepare an order.
Thank you.
Okay, and let's see if. Have you had any communication with Ms. Payne? She's not in the waiting room currently. I'm gonna call. I'll call someone else. If you wanted to check just to see if maybe she's hung up in another court or something, I don't want to keep you waiting around here all morning, but she's not there. I was gonna call your case next. But
This is kind of a pattern.
I understand that, but if you could at least check and find out what's going on.
Good morning, Your Honor.
Good morning. So, Mr. Navarre, I wasn't sure from the motion whether you were involved in Bentley versus Blackwell. Is that why you're here this morning?
I am, Your Honor. I did enter a limited appearance and filed an answer.
I didn't get either.
Judge, I can, if you give me a minute, I can email them to you.
You can do that, but why don't you just go ahead and respond when you have a chance? I'm assuming.
Okay, Judge. I'll do
Ms.
that. I'll go
Girding-
through my answer.
And Ms. Girding, I'm assuming you received his response?
Good morning, Your Honor. Catherine Girding. Yes, I did receive a response late Tuesday evening.
All right, so Ms. Girding, on behalf of the plaintiff, Mr. Navarre on behalf of the defendant, and both parties are also present.
Thank you, Judge.
Go ahead, Ms. Girding, with your motion.
Good morning, Your Honor. Catherine Girding appearing before you for plaintiff William Bentley, who is actually seated to my right, and agrees to proceed via Zoom. Today is the time and date set for a motion regarding parenting time. The parties have one minor child. She is approximately 14. She will be 15 in a few days, 5 days to be exact. The parties have joint legal custody. Defendant has primary physical custody. The current order in place is dated back from May 2010, which gives Mr. Bentley parenting time every other weekend, Saturday 10:30 a.m. to 6 p.m. on off weeks, and Friday from 4 p.m. to 6:30 p.m. and 5 consecutive days over the summer with notice to plaintiff. This case is a case where the co-parenting between the parents is almost non-existent. Plaintiff has reached out to defendant, and she's been unwilling and does not encourage the continued parent-child relationship with plaintiff. The child does ask for additional parenting time with her father, where her mother gets irate and yells and tends to punish her. It is in the best interest of this child to have a strong relationship with both of her parents. And the parenting time should promote a strong relationship between Sage and her father. The parenting time should focus on fostering the relationship between the child and the child's parents. In this case, the order that we have currently does not even match the reasonable parenting time from the FOC. Additionally, there have been some unilateral decisions made by defendants regarding the child's therapy. The child was in therapy. She has been removed 3 different times without consultation with her father. Additionally, from the response of pleadings, it's my understanding that defendant has gone through a rough divorce, and Sage has discussed that with her father too. So I do think that this child needs to be placed back in counseling. So, and additionally, that if the court deems necessary to appoint a guardian ad litem moving forward. Therefore, at this time, what we are asking for is for parenting time to be revisited. We would like a 50-50 at minimum, at least a reasonable parenting time standard set by the object in front of the court. We would like the court to order the child be placed back into counseling and appoint a guardian ad litem if the court feels necessary. Thank you, Your Honor.
Thank you. Mr. Navar?
Thank you, Your Honor. And Your Honor, as far as the custody order that entered in this matter back in May of 2006, that indicates that they share legal custody, that they are awarded legal custody jointly, and that the defendant, my client, has physical custody. It further states that the plaintiff and defendant shall each have the right to share equally in educational decisions, management and control of the child's estate, and each shall have the full legal capacity as a parent to authorize emergency medical treatment for the child whenever an emergency arises while the child is in that parent's care. That's what the final order states as it relates to that issue. Mr. Bentley has not been actively involved with these types of decisions for the child. My client has always apprised him and advised him of major issues that would fall into the joint legal custody category for the child. My client has been going through a divorce. It is not finalized yet, but that's merely because the judgment hasn't been signed yet by the parties, attorneys, and the judge in that case. It's a 14-year marriage approximately. There was some, I think Sage was having difficulties as it relates to her mom and dad going through the divorce. Her stepdad suffers from PTSD. Her father suffers from PTSD. Her father has had chronic alcohol issues, Your Honor, and He was charged and pled and was sentenced for 270 days in jail on a case that for some reason was amended in April of this year and reopened. There was something that entered back in September of this year regarding that case. I had requested the clerk's office provide me copies of those documents. I haven't received those documents, but that's case number 17-5524-FY. And the client's, the father in this case has also had some domestic violence issues, which were documented in a police report that I had attached as an exhibit. He and his then girlfriend were charged with disorderly conduct. They'd been up drinking all night. They had contact with the police at 5:30 a.m. One of the complainants in that apartment complex at the Oaks indicated that this is a frequent occurrence. About 6 months later, the same officer responded again to a complaint, and Mr. Bentley was not cooperative. He was combative. He was resistive, and he was charged not only with disorderly, but also charged with resisting, obstructing, and opposing. The third offense, drunk driving, occurred about 3 years ago. The ROA indicates that he pled guilty to that, and he was sentenced to 270 days in jail. During that time, Judge, it was never disclosed to my client that Mr. Bentley was in jail and incarcerated. And his mother was riding on his coattails to exercise grandparenting time with the child. And the child has a good relationship with her grandmother, Bentley. But that was not disclosed to my client. She was not made aware of that. It's her position that the child was made to be complicitous in that and not revealed to her mother, which she did not, that parenting time is being exercised not by her father, but by her grandmother. As it relates to the issues at hand, I would say that this motion regarding parenting time is a motion to change custody, and you don't have jurisdiction because there's no threshold clearance of ad varca, no proper cause, no material change in circumstance that would warrant a change in custody in this case. They ask for week on, week off parenting time. That changes the child's residence. That changes the established custodial environment, which has always been for nearly 14 years with my client. Judge, this is really, you get down to the guts of it, this is about a cell phone and social media use. Sage is a sophomore at Western Schools. Mr. Bentley resides in Northwest School District. My client resides in Springport School District. And we have indicated in our response that my client had filed a motion previously in this matter to have supervised parenting time with for Mr. Bentley with Sage because of these issues of domestic violence that have occurred and because of domestic violence that's occurred in the past in the presence of the child against my client. Albeit a long time ago when the child was young, but nevertheless, that's kind of the backdrop of the conduct of Mr. Bentley. He's argumentative, he's combative, and he does not communicate with my client. And an example, Judge, of what happened to bring this whole thing to a head was on Tuesday, October 6th at 4:29 p.m., Mr. Bentley, for the first time in 2020, called my client's cell phone directly. He was trying to get a hold of Sage. Sage has been having some discipline issues and throws a fit when the cell phone use or data plans or social media use is limited as a consequence of her being disrespectful or violating house rules at my client's residence. My client reached out in January of this year to try to see if Mr. Bentley would go to the front of the court to have some mediation so that they could coordinate in their residences to address the issues of the cell phone use of the daughter, the data plans, the discipline issues that have been occurring due to different rules in their respective homes. And that request was ignored by Mr. Bentley. Sage has experienced additional stress due to her stepfather and mother going through the divorce, but that's finalized almost, and she's doing much better as it relates to that. And one of the problems is that, you know, they're saying she's cutting off all access. He's got access to my client's cell phone. He's got access to my client's landline, all of which can be utilized for communication when Sage's cell phone is taken away for discipline purposes. So what has happened is Sage's grades have gone down because she's schooling remotely, and she's had some issues about her grades. And so my client monitored the phone, determined that there was excessive use during school hours of the cell phone. She was texting and communicating with Mr. Bentley. She was texting and communicating with her stepdad, Christopher. She was texting and communicating and accessing social media with her friends. So my client, and the rule at school when it's in person is no cell phones during school. So my client implemented a rule of no cell phone during school, and what happened? Correspondingly, her grades have improved. She's having some struggles with Algebra 2 Advanced. She's doing better in that class. She's got an advanced placement English class, and she's got a chemistry class, which is not intro to chemistry, but it's the class where she has juniors and seniors in that class. She has French 1 online through the Michigan Virtual Institute. She's got concert band. She plays the sax, alto sax. She's got a U.S. history and geography class, and she's got an art class. She's a smart kid, but she needs to apply herself and not be on the phone. So she's almost 15. She's developing as a young teenager, and you know, from an emotional and developmental standpoint, she's got that going on, as well as social pressure with her friends, trying to navigate online schooling, dealing with the divorce, and other issues. So what's happened a couple of Tuesdays ago on the 6th is the first phone call from Mr. Bentley to my client. And he says, hey, I've been trying to get a hold of Sage. I'm not sure what the conversation was exactly, but he was advised that she does not have phone privileges during school, and that she was grounded from the cell phone that evening for being disrespectful, and that he could call her tomorrow on Wednesday, the 7th, after school. So what does he do? He calls the police. Then he sends the police over there to do a welfare check at 7 o'clock that night. And so Jackson County Sheriff's Department deputies respond to my client's residence, confirm that everything's okay. Sage advises the deputy that she was working on schoolwork that day and was grounded from the phone because she was disrespectful to her mom for the evening. And what's the deputy do? He says he's going to reach out and contact Mr. Bentley and let him know that everything's okay. And he also compliments my client as to her parenting skills by limiting Sage's cell phone use. What happens next, Judge, is well, there was another incident where she spent an overnight with, which happened previously. That was on Sunday, September 27th. So Sunday, September 27th, she spends an overnight at her dad's because she's having a meltdown, and it's a very over-the-top stressful day for her because their dog Piper ran away, and she thought she had lost the dog, and it was very upsetting to her. And that was a several-hour thing before they were able to locate the dog and get the dog back that got off its leash. She was doing poorly in school. She had failed a math exam earlier that week. She was having some challenges with her friends as far as having difficulty with them. And it was just a kind of an over-the-top thing. My client said, hey, look, there's going to be some cell phone restrictions and social media restrictions because of her declining schoolwork. She needed to concentrate on her schoolwork. And so, you know, she's upset because for a teenage girl, the cell phone is their universe and they can't live without it. So she was yelling and screaming at her mom, and her mom decided that, hey, I'm just going to call Mr. Bentley, see if he'll take her for the overnight and make arrangements for her to start school timely the next morning. So that happens. But what doesn't happen is that on Monday, the 28th, she doesn't sign in on time for her Algebra 2 advanced class. And she had some assignments that were due that they were working on the day before at her mom's. And so she gets a missing mark because she doesn't turn her assignment in timely. So it was marked first classes, it was that Algebra 2 advanced class. The next morning, my client texted her a couple times at I think about 7:19. School starts at about 7:30, 7:35, and no response. Text her again, no response. So she assumes that the child is allowed to sleep in, gets to class late, and gets the missing late mark on the first assignment
Mr. Navar,
to that day.
Mr. Navar,
Yes.
I've heard enough.
Okay, Judge.
We're not having an evidentiary hearing today. What we're talking about, has a threshold been alleged that would justify the court to revisit parenting time and or custody?
Judge,
My
I would say
understanding of the
no.
law, I'm talking, Mr. Navar. Please
Okay,
do not
Judge, I
interrupt.
apologize.
My understanding of the law is that if a threshold is alleged that impacts a change in circumstance or other good cause that impacts one of the best interest factors, that I at least have to take testimony to determine whether or not that threshold has in fact been met. What has been alleged here is that the defendant is interfering with the parent-child relationship of the plaintiff. Now, you've given me a whole lot of ammunition that I would hear at an evidentiary hearing, and if it's proven true, your client would prevail. But instead, what I've got alleged, I think I can't decide based on your recitation of all the bad things that have happened, which I'm not questioning, but I don't think today is the time for me to hear all that litany of offenses. If indeed everything you say comes out, I would say I'm very unlikely to change parenting time or custody. And in fact, if in fact what's happening is mom's trying to be a good parent and dad's trying to undermine her in being a good parent, he may end up losing some parenting time. But I don't think I can decide that based on arguments. I think I have to decide that based upon evidence. So here's what I'm going to do. I'm going to order an evidentiary hearing regarding parenting time and or custody. I'm going to appoint an LGAL. Is there any objection to Mr. Michael Kelly?
No, Your Honor.
No, Your Honor.
We'll appoint Mr. Kelly. He does a thorough job. After Mr. Kelly issues a report and recommendations to the court, I will have Dawn get a hold of both of you to schedule a time for the evidentiary hearing. At that evidentiary hearing, I will focus initially on the threshold. If a factual basis to meet the threshold has not been established, I can simply deny the motion there, unless I hear enough in that context to convince me that I ought to be looking at limiting the father's parenting time or entering some kind of an order that keeps him from undermining mom. I will do that. My word of caution to both parents, and I've only heard allegations today, okay? I haven't heard facts, I haven't heard testimony, but undermining the authority of the other parent is absolutely the worst thing you can do for a child. I understand that particularly in the mother-daughter relationship, as the daughter reaches the mid and upper teen level, there sometimes is a conflict that arises there. And if dad is playing to the daughter's complaints about mom being unfair about taking away my phone or unfair about making me do my schoolwork, you shouldn't be undermining her. You should be supporting her. Ms. Girding, you'll prepare an order for the court signature?
Yes, I will, Your Honor.
Judge, is there a possibility that we may have some kind of an interim order that addresses gives a prohibition to cell phone use during school for the child? My client has asked Mr. Bentley not to communicate with her by cell phone or otherwise. Earlier this week during school, he didn't follow that. He was texting her a couple of times during school, sending her messages through a Pinterest app, and we would like at least an interim prohibition of cell phone use during school for the child, because that's one of the rules of the school for in school. It should apply and pertain to virtual school as well.
Ms. Girding, do you have any objection to such an order entry?
I would ask that it apply to both parties, Your Honor, as the day that the child was at Mr. Bentley's house, mom was doing the same thing. So prohibit cell phone unless for emergency.
Mr. Navarre didn't ask for an order specific to your client. He asked for a general order prohibiting telephone, text, cell phone communications, and any other online communications. I don't know that he said that, but I know there's other ways you can send instant messages that don't use cell phones. I would prohibit that by either parent during school hours. I think that's a very reasonable request.
I will add that to the order, Your Honor.
Thank you. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor. Have a wonderful rest of your day.
Oh, Ms. Payne is present.
Do you have a party, John?
Yes, I have one party.
We need to find out from Ms. Payne if her client intends to appear.
I don't.
Okay, for the record, Stinson versus Stinson. Ms. Hamilton is here for the plaintiff. Ms. Payne is present via Zoom for the defendant, and the plaintiff is also present via Zoom. Ms. Payne, did you expect your client to be participating? I don't see him in the waiting room.
No, not for today, Your Honor.
Okay, thank you. So I think we're here on the motion to enforce parenting time order.
Correct.
All right, go ahead, Ms. Hamilton.
Thank you very much, Your Honor. I want to try to be as brief and concise as possible. We seek the court's assistance because of something unusual that just developed since the beginning of this school year. there has been no conflict regarding whose weekends are which since this judgment was entered in October of 2017. Then since the start of school this year, this academic year, Mr. Stinson has been attempting to force a switch of weekends. And my client really tries to be conciliatory whenever she can be, but it doesn't work. She is really committed to the current alternate weekend pattern because, if you remember, there's 2 other parenting orders. We carefully crafted this one to coordinate with regarding her 2 other daughters that she has full custody of. If we force a flip-flop of the weekends like Mr. Stinson is trying to do, little Lucas will not have any weekends with his sisters. It's more poignant this year because the oldest child has started as a freshman at a college out of town. So she doesn't always hit every single weekend. She gets most of them, but it makes the time that Lucas spends with his 2 sisters and the time they spend as a family all the more precious. You might be able to see from my motion, Ms. Stinson reached out and said, what provision of the judgment are you relying on? No response, only bullying. Only Mr. Stinson going to the school on all the weekends he thinks he's supposed to get Lucas and trying to pick him up when it's not his weekend. There was no answer filed that I got, so I'm taking the allegations in my motion as admitted. But I want to just point out to the court, I don't see if there's any other way to interpret this. If you'll take a look at the calendar that we attached to the back of our motion, it shows that the last weekend before school let out in the spring of 2020, Mr. Stinson had. Mrs. Stinson took the first weekend of the summer, as she would have done in the alternating weekend pattern. Then after school started, because Mr. Stinson had the last school year weekend, Ms. Stinson took the first 2020 fall school year weekend. Now, Mr. Stinson, the only thing that he's mentioned to us is the judgment gives him the first weekend after the start of school every year. There's no such language in the judgment, nothing of the sort. The pattern that Ms. Stinson is asking you to enforce is the same one that if you'd continued the every other weekend all the way through the year since the beginning when the judgment was entered, these are the weekends that she would have, those are the weekends that he would have. Similarly, if you look at what happened between the dismissal of school in the spring, last spring, and the start of school this fall, it's still the same pattern of weekends. So we're at a loss. We can't get any communication. We only get bullying.
Well, let me see what Ms. Payne's client's position is.
All right.
Your Honor, I didn't want to cut Ms. Hamilton off. So 2 things. First, she is correct. The rotation should be consistent throughout the school year and the summer parenting time. Had I known Mr. Stinson agreed with that back in the summer, we would have addressed it, but I did not know. So she's correct. The more important thing for us is that we are midway through a trial on modification of parenting time in custody. The parties were referred to do psychological evaluations that mom has not done. So until we have the completion of that trial, Ms. Hamilton is correct. The weekend rotation needs to be the same, which is why I didn't file a motion response either. I did try to communicate that to her office. So we don't dispute the rotation that's set forth in her motion. I just need to make sure that we are rescheduling the continuation of that trial to modify parenting time.
May I respond?
Yes.
I just really want to keep us focused. But since that issue was raised, we are in the middle of a mess. We have been back to court on it. My client told you, Your Honor, when you asked both parties why neither had gotten their psychological evaluations done at that time, my client told you there is no way, the cheapest psychological evaluation that I have found is $1,500. And there is absolutely no way that I can ever come up with $1,500 on my budget at one time. Now that was made tremendously more complicated for her when she went without child support. And we'll get to that in a second because we have an order for you today. She went without child support at all from October until Mr. Stinson came into my office a week ago and paid $49.80 pursuant to the new enforcement order that you signed that was as a result of our bringing 2 separate motions to try to get him to pay child support. So when Ms. Stinson came to court and said, there's no way I can get that kind of money, you said on the record, and I don't know if this is a direct quote, but close to it, if she doesn't have the money, she doesn't have the money. So I don't know where we go with that, but I'm hoping that you can look back and you can see that our theme from day one in this case, which I'm not sure you really bought, I'm not sure you really were convinced, but our theme was she gets bullied. And when we come into court, either counsel starts talking about something else that's not before you, or Mr. Stinson starts talking about something else that's not before you. And the result is we got this sadly coupled up mathematical error that happened at the last time we were in court. And I think that you're familiar with that.
All right, well, let me stop you.
Okay.
Let's deal with one issue at a time. I'm granting your motion regarding the parenting
Thank
time,
you.
since Ms. Payne agrees that your client is correct.
Had I known that, we would not have had to come to court today. So that's more attorney fees that is exhausting my client.
Ms.
I don't mean to
Hamilton,
interrupt you, but I just
contacted her office
Okay,
insurance, but she did file the
had no
motion.
communication. No communication.
Just- Sorry, Judge.
what she said was you did not seek concurrence before you filed your motion.
The last 4 emails I've sent Ms. Payne have gone unresponded to.
You did
So
not,
one of those
I didn't-
emails sought concurrence?
It did not, but she won't
Well,
answer
then,
me, so.
then don't complain about attorney fees about this motion.
Ms. Hamilton was
Okay,
sending emails to
next item I want to address is, and that's one of the things I was going to ask this morning, was the fixing the last order. Have you agreed upon the language to fix the last order?
No, I sent it to Ms. Payne yesterday at 3:18. I've not heard from her.
Did you get that yesterday?
I did, and I also responded by email to the court indicating that we agreed with Ms. Hamilton. The judge, you
Wonderful.
emailed about,
Would you bring the order? Would you get that, please, Peter?
If I had been copied on that, it would save
Sure.
some time. For the record, can we check the email address that you're sending things to, Jennifer, just to make sure, because I'm not getting responses from you.
sure. It is jhammy@sbglobal.net.
That's correct. Do you know when you sent it?
Last week, when the court emailed both of us asking if I agreed with your motion to reconsider.
I check every day, but I didn't check the spam folder, so I'll do that before I make a representation.
So just so we're clear, Ms. Payne, this order, which is actually a marked up order of the second amended order, says that on or before October 7, defendant shall pay the sum of $49.80. And defendant will receive a fully executed direct credit for the sum of $49.80, representing child support from April 1st through August 31st. And that's what you agreed to?
Yes, Your Honor, that's correct.
All right, I'm going to sign that now. Peter, if you could return this to Ms. Hamilton, please. Okay, and I guess we should be talking about at what point the court schedules. I'm not sure if it's the continuation of an evidentiary hearing or the commencement of an evidentiary hearing. Which
Continuation.
is it?
It's continuation.
All right. Now that Ms. Stinson has received the back child support, can she make arrangements for the psych eval?
That's unlikely. He's still 2 months behind, and she was so far behind in bills that I can't imagine she'd be able to use child support money to pay for a psychological evaluation. I will say to the court that if Mr. Stinson would pay for her psychological evaluation, she'll make herself available in a heartbeat.
Judge, we already argued.
One straggler.
Let her
One
finish.
straggler. If you'll remember correctly, Your Honor, even this child support order was based on Mr. Stinson's income at a grossly under disclosed amount. Mr. Stinson initially did not respond to the friend of the court's request for income information. Or if he did, he gave his income information without BAH and BAS supplements, which under the guidelines are supposed to be included, and they are tax-free. So the rate that he just paid is a fraction of what he really owes. And there is an order pending that says his support's supposed to be reviewed with the new information. He did get that information to me.
So the issue still then is the ability of the plaintiff to be able to afford a psych eval. Do we have, has Mr. Stinson had a psych eval done, Ms. Payne?
No, Your Honor, you referred both of the parties to the Mulderrys. We argued on the record about whether he would pay the cost or they would pay it 50-50, and the court already made a determination that they would pay it 50-50. That was at the conclusion of our last trial day.
So neither one has had a psych eval.
No, because they're supposed to schedule to do them together as part of one evaluation with the Mulderrys.
I want to just throw out to you, if this helps at all, Your Honor, we have learned, my client shopped and shopped and shopped for one that she might be able to afford somehow. And we did find out that Dr. Lauder here in town charges slightly less money than the Mulderrys, and there's no drive to Adrian. So if you could order Mr. Stinson to perhaps front the money for Dr. Lauder, we'll save him a few $100s, and then at the conclusion of the testimony, if you feel that it's important for Ms. Stinson to pay him back, we could probably work out something along those lines on a time basis.
Has there been ever an LGAL appointed in this case?
No, Your Honor.
But if you do, I'd like to ask for Rebecca McCluskey or Shelley Dungan.
So as an alternative to psych evals, understanding the expense and knowing that we have a fund available to pay for an LGAL here at the court, would both parties be amenable to me dropping the psych eval? And Ms. Payne, if your client really wants a psych eval of Ms. Stinson and is willing to pay for it and is willing to submit to one himself, I will offer that option to him.
Okay.
If he's convinced that, you know, Ms. Stinson is the problem here, then let him pay that cost. But I'm going to drop it otherwise.
Okay.
And I will appoint an LGAL. I want a very specific order done to the LGAL. I have some LGLs who don't do written reports, who participate in the hearing and don't give me their recommendation until the hearing is completed. That's unacceptable to me. I need a full written report from the LGAL prior to the evidentiary hearing.
Okay,
There will be 2 reports prepared, one for my eyes only that recites the LGAL's communication with the minor child. How old is the child here? He's pretty young still, isn't he?
Yes, 7.
7?
Yes.
I still want him to be able to talk, obviously, to the 7-year-old. And the other report that goes to the attorneys and to the court does not include whatever it is the LGAL learned from the minor child.
okay,
And though that, under those conditions, yeah, I often refer these to Michael Kelly because he does that. And I find
Yeah.
it's extremely helpful for me to get those reports ahead of time. I also find it helpful for the parties to get those reports ahead of time because sometimes it often leads to a resolution. I don't want a report that's issued at the time of the hearing, either orally or in writing, or one that's issued at the conclusion of the evidentiary hearing, because I've lost the potential settlement value of such an evaluation. So under those conditions, I don't care. Ms. McCluskey would be fine. Ms. Duncan would be fine. Obviously, Mr. Kelly would be fine, whoever you can agree on.
okay.
I just did one with Mike Kelly, and I think the world of him. He missed a really important issue that a psychiatrist found, and everything was just completely flip-flopped across the hall, and he just missed it. And so I'm not sure.
I'm not arguing you to agree to anybody. My preference for Mr. Kelly was simply because he does
Okay,
the report
okay.
in advance, and everybody gets it in advance.
We'll make sure that whoever does it gets, I'll put that
Yeah,
right in
just
the
put
order.
that in the order. Ms. Payne?
Yeah, Your Honor, could we maybe set this matter over for 1 week so that Ms. Hamilton and I can talk and contact potential options and see who's willing to work with us? I think it's a great, I just want to make sure that we have the ability to interview and see what costs before we.
The costs will be paid by the fund that the court
Oh.
has, so you don't need to worry about that. It's marriage fee funds that the county collects every time it issues a license, and it goes into a pool that's available to pay LGALs.
Okay,
And it needs to be an attorney, right?
Pardon?
Needs to be an attorney?
Oh, absolutely. It needs to be an attorney.
okay,
And yeah, I'm fine with giving you time to talk about that. And you
Okay,
can,
yep.
if you can agree, each of you make your recommendation, and I'll choose from between those 2 recommendations.
okay, very good. All right, thank you, Your Honor.
Okay.
Am I to prepare this order?
If you would, please, since you're already preparing the order, granting your motion today.
Will do.
Okay, thank you.
Thank you, Judge.
Good.
And is it possible for me to take down the second amended order so the clerk can get it and I can get it to the friend of the court?
I thought he gave it to you.
Did you?
The piece of paper I just handed you?
I think you put it away.
I wasn't watching.
Okay, thank you. That concludes our hearing.
Got it. Well, I didn't get to bless you because you didn't sneeze. You usually do that before court, though.
Okay, next up is Prevost versus Eiler. And I'm having trouble getting Mr. Falahy into the room. Ms. Prevost, have you hired an attorney?
I have not.
Okay. The reason I ask is there is an attorney out in the waiting room. I wanted to make sure she wasn't on your file.
Nope.
We're having trouble getting Mr. Falahy into the Zoom meeting. I'm not sure what the difficulty is. Looks like it's hung up. And I can't do anything until he probably logs off and then logs back in.
Want me to shoot him a quick email, Judge?
Yeah, you could try, although he probably realizes that there's a problem at this point. But wouldn't hurt to let him know. I'll just suggest that he log off and then try to log back in. Good morning, Ms. Kerr. I just wanted to let you know that for some reason, we're having trouble getting Mr. Falahy out of the waiting room.
Okay. Yeah,
I
he let me
clicked
know
on
that
it.
he's still in the waiting room too.
It tells me he's joining, but it's been telling me that for a long time, so there's some kind of a malfunction at his end. We sent an email to ask him to log off and log back in. If you happen to have his cell number,
Yes,
you
I
might want to
texted
shoot.
him. I'll text him right now and tell him.
Okay. So, Mr. Enright?
Yes, sir. Can you see me?
Yes, I can. I just wanted to I didn't know if you were able to hear what I just said to Ms. Kerr. We're having trouble getting Mr. Falahy out of the waiting room and into the Zoom room. I just wanted to let you know why we're not doing anything at the moment.
Yes, sir. I understand.
Judge LaFlamme?
Yes.
I did have another issue aside from Mr. Falahy's motion. I'm not sure if you're aware, but Ms. Hyatt was picked up on a bench warrant that you apparently issued back in June regarding a failure to appear for a hearing prior to the trial that started on the 23rd of June. And that bench warrant, it was her understanding it was to be lifted, at least that she recalled you saying I would take care of it on the record. I'm not sure what happened, but it did not get lifted. And she was picked up yesterday and spent the night in jail. So she's still in the Jackson County Jail right now, awaiting this bench warrant issue.
I will send instructions to have her brought over.
Okay, I appreciate that.
What's the best way to do that, Shannon? Call that?
Pardon me?
What's the best way to have her, Christy Hyatt, brought over from the jail?
They don't bring people over, you just mean by Zoom, right? Isn't this the one, Peter, that Dawn emailed us about?
I think so. I didn't listen to the
She-
voicemail.
Yeah, I would just call the jail and have them bring her over to the meeting room. That's probably why I've got all these missed calls from the jail too.
Hi, this is Judge LaFlamme. Would it be possible to have Ms. Christy Hyatt brought into my Zoom hearing? All right, I'll just watch to see when she's logged in. Thank you. Okay.
There he is.
Good morning, Mr. Fallahy.
Morning, Your Honor. Sorry for the technical difficulties there.
No problem. Let's do Prevost versus Eiler first.
Thanks, Judge. My client's here in our waiting room. I'm going to go out and get him really quick, okay?
And Shannon, the plaintiff, Ms. Provost, is present for the hearing.
Thank you very much.
See you here, okay? Okay, Judge, my client is here and we're ready to go.
All right, I've read your motion. Basically, you're looking for an order confirming the parenting time schedule that the parties have been observing since 2016.
That's exactly
Ms.
right,
Provost?
Judge, yes.
Ms. Provost, do you have any objection to that?
Your Honor, this has come about due to some recent incidences with Landon's behavior in school and lack of consistency. I was in the process of requesting a motion to change parenting time. And I guess I'm not sure
Okay.
that I necessarily agree with the change.
All right, well, if you're unwilling to consent to it, I don't have any choice but to schedule an evidentiary hearing. And if in fact this is the schedule you've been following since 2016, I would be looking very hard at the reasons why you think you shouldn't be following that schedule anymore. So we'll find a date, Mr. Fallahy, and we'll get this scheduled for a hearing.
Thank you very much, Your Honor.
Thank you, Your Honor.
Just in front of us, Your Honor.
Yes. Okay, so let me see. Let's take care of Harsh versus Hyatt. right, so first up is Mr. Palahi's motion to withdraw. I don't have any opposition to the motion. And Mr. Harsh is not here today to object to the withdrawal. The matter was scheduled for 8:30. It's now almost 10 o'clock. Mr. Falley, I'm going to grant your motion, assuming you still want me to.
Yes, sir.
Okay, and I think I saw an order. Yes, here it is. Let me take care of that. Okay, this matter is up for a, I know it shows up somewhere else on my docket. I can't remember. Well, maybe not. I was thinking that it did.
I don't think it's on for any,
All right, well-
any other hearings right now, Judge.
It's not, okay, I just thought it was when I looked at it yesterday. But it is in front of me today because Ms. Hyatt was picked up last night on a bench warrant. Ms. Kerr, refresh my recollection again as to what happened here.
It's my understanding, Your Honor, that you had a miscellaneous hearing in May, and my client did not appear for that hearing. So you issued a show cause, and that was to be held, a show cause hearing on 6/4 of 2020. My client did not appear, and so you issued a bench warrant at that time for her appearance.
Okay.
You then amended it on the 9th and again on the 10th. So it was filed with this court. The last one was issued on the 10th. It says no bond, charge is contempt because she failed to appear. However, you then held a trial on the 23rd of June in which she did appear, as well as Mr. Fallahy at that time made his appearance with the plaintiff. They held about a half-day trial. It looks like things weren't going in a position where you felt comfortable making a decision, so you appointed a guardian ad litem, Mr. Kelly, and Mr. Kelly pursued an investigation. He submitted that report just in September, toward the end of September, and then Mr. Fallahy filed his motion to withdraw. So that's where we are. On the 23rd, my client, which she's here and can obviously state since I wasn't present, it's my understanding that you had indicated you would be lifting that bench warrant because she had appeared in court and the process was moving forward. So she didn't know the bench
All right,
was still there.
And if I indicated that I was going to recall the warrant and failed to do so, my sincere apologies to you, Ms. Hyatt. I am going to order that you be immediately released.
Thank you.
It might take a little while to get you processed out, but we will take care of that.
Okay.
Shannon, what's the best way for me to do that? I mean, when they're here, I sign, you prepare something, I sign it, and then they take them back and process them out. She's not here, she's in the Zoom room. Can you do what you would normally do, and then we can email it over to the jail?
What would be the easiest way? Yes, but the bench warrant's gonna have to be recalled, and I wouldn't do that. I can get her out of jail with a.
Well, that's most important. I want to get her out of jail right now. So whatever that is, you prepare for me to release somebody. Why don't we do that? Let me sign it, or if it needs to be signed, and then let's email it to booking. Do you have an email for booking? I'm going to call and ask. How's that?
I do for Amy, but I don't for booking.
Booking.
Good morning. This is Judge LaFlamme. You're currently holding Christy Hyatt I want her released. What kind of paperwork do you need, and who do I send it to get it released?
Okay, do you want to send an email or fax?
Email works great.
Okay, it's gonna be E. Anderson, and that's O-N on Anderson, at mijackson.org.
Wonderful. We'll get that right over. Thank you very
All
much.
right, thank you, bye-bye.
You got that?
Yep, I'll do the paperwork and Peter can just do it, just send it from our fax.
Let's email it. He could scan it and then email. Am I gonna fax it to him? That's what you meant.
yeah.
Okay, sorry. All right, Ms. Hyatt, we'll be getting that paperwork over momentarily.
Thank you so much. Appreciate that. And are we going to be setting this then for another pretrial or a trial, since I'm going to try and contact the defendant personally to see if we could work something out, but I'd like to have something on the docket just to move forward with this divorce. It's, over a year old at this point.
We'll set the matter for a pretrial and trial.
Okay.
Well, refresh again. You told me this earlier, but you said at some point I ordered an LGAL. At what point did I do that? At a pretrial?
After starting the trial, you started the trial on the 23rd. They did about a half day of testimony, and you said,
So,
I'm gonna do an LGAL. You appointed Mike Kelly on the 23rd. It was issued on the 1st of July is when that order went in for the LGAL. He just completed his investigation and he sent you his thorough report with all of the best interests.
yes, yeah, and I've gotten that. So what I'll be setting it for is continuation of the trial.
Yes, okay. Yeah. And then I believe he also had sent a communication regarding the plaintiff's behavior following his report.
I got that as well.
Okay,
Okay, did you have any other business before the court today, Ms. Kerr?
I do not. Thank you, Your Honor.
Have a good day. Mr. Fallahy, you're here on Enright.
Yes, Your Honor.
Okay, and Mr. Enright is present. Sir, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your full name for the record.
Joseph Michael Enright.
I'm so sorry.
You can put your hand down. Go ahead, Mr. Fallahy.
Thank you, Your Honor. Good morning, Mr. Enright.
Good morning.
Can you hear me okay?
Yeah, I can hear you just fine.
All right, sounds good. I was having some technical difficulties earlier, but it sounds like we've gotten them resolved. Joe, do you remember signing the complaint for divorce in this case?
Yes, I do.
Were the allegations in the complaint true when you signed it?
Yes.
Do they remain true today?
Yes, they do.
As far as you know, is your wife pregnant at this time?
No.
And you and she, and specifically her name is Brecken, you two have gone over, reviewed, and agreed to a consent judgment of divorce in this case, which you've both signed. Is that correct?
Yes, that's correct.
And do you think that it's a fair resolution of all of the property issues in your that have resulted from your marriage?
Yes, I do.
Do you think that there's any chance for reconciliation at this time between yourself and your wife?
I don't know. Potentially someday.
But as of right now, do you think there's an, as of right now today, is there any chance for reconciliation?
No.
Thank you. I don't have any further questions, Your Honor. I had emailed the signed consent judgment of divorce to your staff earlier, and we would ask that you sign and enter that judgment.
Okay, and Mr. Enright, can you confirm that this is Brecken Enright's signature on this consent judgment of divorce?
Yes, that's her signature.
Thank you. Well, I'm satisfied based on the proofs that there's been a breakdown in the marriage. To the extent that the objects of matrimony have been destroyed, there remains no reasonable likelihood that the marriage can be preserved. Sorry, I was just looking to make sure Ms. Enright wasn't in my waiting room. Does not appear to be. I am going to sign this. So, Mr. Enright, where do you serve?
Sir, right now I'm stationed in Lansing, Michigan.
Thank you for your service.
Thank you for your support, sir.
Okay, I have signed the consent judgment, and we will get copies to you, Mr. Fallahy, for Mr. and Mrs. Enright. Thank you.
Thank you, Your Honor. Have a good day.
You too. Have a good day,
Thanks,
sir.
Joe.
Thank you.
All right, let's see. A bunch of people have appeared in the waiting room. Looks like Rice is up first. I just let a telephone into the courtroom, prefix 358. Could you identify yourself, please?
Yes, Brandy Stubb.
All right, give me just a second. I haven't called your case yet, but I'm going to associate your name with it so I know when to bring you back in.
Okay, thank you.
You're welcome.
Hello,
Good morning. Sir, what's your name?
Samuel Bradshaw.
So, Mr. Bradshaw, I'm working another case right now, but I wanted to find out if you were one of the parties since it didn't have your name associated. So I'm renaming so I know who you are, but I'm going to put you back in the waiting room till I call your case. Good morning. Sir, what's your
Okay,
name?
thank you. Samuel Bradshaw.
Okay, and Ms. Cooper, we've got you in. I'm trying to figure out if we have Mr. Rice.
Okay.
There's one other phone number here. I just let a telephone number prefix 936. Could you identify yourself, please?
Ashley DeForest.
All right, Ms. DeForest. I'm calling another case right now. I'm going to rename your phone so I know who you are. I'll know when to let you back in, okay?
Okay, thank you.
You're welcome.
I have two different numbers for Mr. Rice. One is, can we see if they're the same ones you have? Or last time he called from his wife's phone. Can't think of her name though.
Ah,
I'm having a
well,
blank.
everyone else that signed in has a name associated.
Okay.
One looks like Yanessa. Does that sound familiar?
No, not Yanessa. Unless he's using someone else's phone now.
Another is Erica Bullinger.
Nope.
Does that sound familiar?
Nope.
Do you have his phone number?
Let me give you what I have. I have a 7320.
Yeah, can you give me the entire number and I'll try to get him on the phone?
Sure, 517-748-7320. And I have a second number too, but they're old.
Well, what's the last four of the number you just gave me?
7320.
7320?
Yes.
Okay, sorry, it just wasn't coming through clearly. And what's the other one?
The last four are 3804.
Also 748?
Nope, that one is 517-960-3804.
All right, well, neither of those phone numbers is logged in. I'm going to try to get him by phone.
Okay.
He may have had some trouble logging in today.
I was surprised how easy it was.
The number you have dialed is not in service.
All right, I'll try the other one.
Your call has been forwarded to an automatic voice message system.
Doyle Rice.
Is not available. At the tone, please record your message. When you have finished recording, you may hang up or press 1 for more options.
Mr. Rice, this is Judge LaFlamme. Your case was scheduled for a hearing this morning at 10 o'clock on your objections to the referee's order. Since you're not present and unavailable by phone, we'll have to proceed without you. All right, I've got one more phone number I'm going to check. I just let into my courtroom prefix 879. What is your name, please?
Erica Bullinger.
Okay, I'm going to name this so I know who you are. I'm on a different case right now. but we'll let you back in as soon as I call your case, okay?
Okay, do you want me to get on Zoom or is telephone okay?
Telephone's fine. I saw you had been logged in earlier, but no, this works. As long as we can hear you good. Sometimes this works better.
Okay.
Okay, Ms. Cooper, Mr. Rice's objection to the calculation of child support was that the child is no longer living with you. Is that true? Ms. Cooper?
Can you hear me? I can't hear you anymore.
I can hear you, yes.
Oh, I can if I put my, oh, it's speakerphone turned off.
Okay.
Goodness.
What did you call Rice? Is that what you mean? Or Cooper?
It's Rice versus Rice. She's remarried. Her name is Cooper now. Okay, Ms. Cooper, Mr. Rice's objection to the child support order was that your son is no longer living with you. Is that correct? And you muted your phone. You need to unmute. I can't hear you.
No, he's not, but he's 19 and out of high school.
Oh, so there should, if he's 19 and out of high school, then there shouldn't be any continuing child support.
No, he graduated in May. Well, he should have graduated in May. The ceremony was this summer.
Okay, I'll notify the friend of the court accordingly. I think his objection was he wasn't living with you. His objection should have been he's he's not subject to child support anymore. I'll make sure that gets taken care of, ma'am.
Yeah, there was a hearing because he owes me a lot of back child support. I thought this was what it was for. I didn't go to the mediator.
Your case is scheduled again at 3 o'clock today for probably enforcement of child support. It looks like that's what it is.
Okay. Do I have to be there today?
You do not have to be there, but if you want to speak to whatever it is Mr. Rice's objections are going to be to why he shouldn't be paying his child support arrearage, you're certainly entitled to participate.
Okay, I did not get anything with information on how to call in. Is it the same Zoom room again?
Oh yeah, everything's the same.
Okay, and can I change my address through the court? The friend of the court stuff is coming here, but I was lucky I got this. It was forwarded to my brother's house. He gave it to me last night.
What is your current address?
P.O. Box 3852.
Looking. Judge's office.
Just a second. We got a phone call.
Is that me?
Yep, our court officer hasn't gotten it sent over yet. Nope, he hasn't sent it over yet. Thanks, that's okay, bye.
Hey, Peter. Stepped away. Okay.
I'm here.
So go ahead with that address again.
Okay, P.O. Box 3852, Nantucket, Nantucket, Mass, M.A.
Okay, hold on a minute. Sorry.
Okay.
Sorry, I thought you were doing this.
Go ahead.
All right, I'm start from the beginning. Sorry.
Okay, P.O. Box 3852, Nantucket, Mass, M.A. MA is the abbreviation. Zip code is 02584.
All right, we've made that change.
Okay, great.
Have a good day.
Okay, thanks. See you at 3 if I can get away from work.
Okay.
Okay, thanks.
All right.
Bye-bye.
You're welcome. Okay, where are we?
You want me to email this over, Judge? Right now?
Scan it and then email it to booking. Shannon should have sent you the email address.
It's on the sticky.
Oh, it's on a sticky.
Sticky?
Oh.
Yeah, on there, that's got that one.
It
Yeah,
fell off.
did it fall?
There it is.
Perfect. I'll send that over right now.
Okay. All right, next up is DeForest versus DeForest. Ashley DeForest is present by phone. I do not see Kelly DeForest logged in. This matter was scheduled for 10 a.m. on Ms. DeForest's motion to enforce the judgment of divorce. So, Ms. DeForest, this is a money judgment. So the divorce decree certainly provides you with protection from having to pay Mr. DeForest's debt, but the way you get relief from this is to seek enforcement of the judgment through normal enforcement of money judgment provisions. You can garnish wages, you can garnish a checking account, or you can satisfy with his assets. I realize you probably don't want to retain an attorney to assist you with that process, but
Yeah, that's kind of what I was trying to avoid.
I get that. If you contact, give me just a second. I'm trying to remember the exact name of the agency. Give me just a second.
Okay. So just to clarify, you're saying that I could garnish I could go after to do a garnishment for him. I don't know if I'm assuming the company is garnishing him as well. Just my fiance had added me to his bank account a few years ago, and they drained our checking account. And ever since then, I've been without a checking account, and I'm a stay-at-home mom right now. I'm doing the virtual learning with my son and stuff. But if I were to get a part-time job, they will, I'm assuming that they will garnish my wages as well. So I just want my life back.
I appreciate that. So far, you haven't had to pay any of this debt, but your fear is they're going to start collecting it from you through garnishment or something else?
I was garnished a bank account, a checking account a few years ago, but I took my name off of the account as soon as I found out, and I haven't had a bank account or wages since then.
Did that happen since the judgment of divorce was entered?
Yes, sir. Yes.
Yes, I mean, whatever amount they garnished from you, you can collect from him, or you can attempt to collect from him. I've
Okay.
already ordered him to pay this, but the only way I can enforce money obligations is through whatever creditor remedies exist under the law. And, I mean, you can try to explore yourself how to issue a garnishment. So far, you've only had to pay whatever it is they were able to collect from you the first time. So you
Yep,
can
that was a
certainly,
small amount. So that's not my major concern. My major concern is when I am ready to go get back into the workforce, that I'm just going to go to work and have to pay for that car that I'm not supposed to.
if that happens, anytime you have to pay any portion of this debt, you are entitled to go against him to try to collect it from him. If you're unsuccessful, what the court cannot do is tell a creditor that they can only look to one debtor. That's between the parties and the creditor. That's nothing I can impact. All I can say is if you have to pay any portion of this, you can try to collect it from him, but you have to use something other than asking me to issue an order, because I've already issued an order.
Okay. All right.
All right. Well, I mean, it sounds like it's a little early for this, but what you would want to do, there's an agency in Jackson that does collection of judgments. I was trying to find their name. It's been a while since I've dealt with them.
The Associates Financial Solution.
No.
Kelly still has not appeared for today, I'm assuming.
I'm sorry, ask that again.
Kelly has never appeared for the Zoom today.
No, he didn't show up.
Okay.
Oh, it's Peter. Yeah, you can send her up. Thank you.
All right, if you might want to write this down, Judicial Services Group. Their telephone number is 788-8898.
Okay.
And tell them you need assistance collecting a judgment.
Okay. And will that help me with only what they've been able to garnish from me, or future garnishments as well?
Whatever you end up having to pay, either through garnishment or otherwise, that he is responsible for. They can help you in going after him.
Okay.
Good luck, ma'am.
Thank you. I had one other question. Is probably not a way to make him have to refinance without my name on it or anything like that. I mean, I think it's probably beyond that point because it's in collection and garnishment, but
I can't do any more than what I've already told you, ma'am. Good luck.
Thank you.
You're welcome.
What do you want me to put on that, Your Honor?
Plaintiff instructed she needs to take steps to enforce judgment. Okay, let's see. We've got done with that. Hughes versus Short. All right, waiting for full audio connections. Okay, Hughes versus Short. Ms. Hughes is present and Mr. Short is present. The court ordered Mr. Short to appear to show cause why he should not be held in contempt for violating the custody order entered by the court on June 1st. So, Ms. Hughes, have you been exercising parenting time?
Since our last court date, yes, with all three of the older children.
All right. And how much parenting time were you denied?
About 2 months of parenting time, so 4 weeks, give or take.
Mr. Short, you acknowledge that Ms. Hughes was denied 4 weeks of parenting time. You were muted. You need to unmute. I didn't hear any of that.
Oh, sorry about that. Can you hear me?
I can now.
I doubt it was 4 weeks total, but this whole thing's just so out of whack that I'm absolutely lost. This is just beyond words at this point with what's going on with this court system and what's going on with this court case.
Well, I'm not here to hear your complaints about the judicial system. You have remedies. If you don't like a decision of the court, you can file an appeal.
Well, it's just that I'm not even getting the appeal letters, and when I do, it's too late. Like, for instance, I had court on September 10th. I didn't even get the official letter in the mail saying I had court on the 10th until September 11th. Judgments are literally being made without me present, and this is absolutely affecting my life, mentally, and every other which way, and the children's as well. This is the third time this has happened in the last year where judgments are being made without me even being aware of court, because I have never once willingly missed court or not showed up.
Again, I'm not here to hear your complaints about the judicial system. You have remedies, exercise those remedies. Complaining to me about it's not going to do you any good. So we've got, you think it was less than 4 weeks? What do you think it was?
It was about a month that he decided he didn't want to go over there because he did not feel safe.
Get the dates out again for me, please.
And he was having horrible anxiety. He was having a lot of issues. There was the issue, so probably 2 weeks of actual parenting time.
Is it just one child involved that you were denied parenting time with, Ms. Hughes?
Yes, my oldest son, Turner. Travis states he refused to come to my house, but when he finally did come to my house, he was all smiles, happy. He said he missed me, that he was excited to be with me. And the text messages that we spoke about in the last judgment was not Turner, it was Travis trying to use Turner's phone to stage messages stating that Turner wanted to communicate that.
I don't need to hear. I'm glad to hear that parenting time is going forward. You say 4 weeks, he says 2 weeks. I'm going to award 3 weeks of make-up parenting time with Turner to be made up 1 day at a time, one day per week until it's paid up, until it's made up. Now.
Okay, what about schooling? Like you granted me the Paragon Charter Academy. I enrolled them. They were supposed to go on October 1st from Travis's house. He failed to take them. When they came back to my house, I struggled getting login information and passwords. I received those. I got the children online. I took them to school for my week. They have been at his house for the last week. They have not done any online schooling. They are not in school today. This is a problem with their education. They need to be in school.
Um, I will address that briefly, but I got a lot of people waiting to get their cases heard. What's the issue with school, Mr. Short?
Your Honor, here's the absolute issue. How I said we had court on the 10th of last month that I wasn't even made aware of until the 11th. For the past 7 years, I've been the one doing their schooling and stuff. I had them all signed up to go to school at Da Vinci, was literally in the process of going to get their computers that day when she decides that she wants to call Da Vinci and say she doesn't agree with it. And then she gets in front of you without me even able to defend myself and puts them in Paragon, which is 10 miles away for absolutely no reason other than spite. This is absolutely insane, Your Honor. She's been off doing drugs the past 10 years. I've been the only one here caring about their schooling and this type of stuff. And she literally found a way to manipulate the system. And this is absolute insanity. I had them all set to go to Da Vinci.
Even though you don't like it, if they're enrolled in Paragon, why in the world wouldn't you have them attending their school session when they're in your care?
They have been doing their online schooling and their stuff like that. Is perjury a thing at this point? I mean, all she does is lie to you in the
with
court.
the school. They have not, I talked to them this morning. They have not done anything this last week online. I have access to their emails, their school logins and everything.
amazing.
They have not done nothing. And
I
they are
had
to
them
be in
enrolled
school
and she
today and they
brought
are
them out
not
of
there.
One at a time.
I mean, is perjury even recognized by the courts?
Perjury is recognized. Only one of you could possibly be telling the truth. Either they've been participating in their online classes or they have not.
They have.
Ms. Hughes
They have
says
not,
the
and I
school-
spoke with Turner's teacher yesterday.
Hold on. I'm talking. That means you be quiet. Ms. Hughes is telling me that the school is telling her that they're not doing their classes. So, Mr. Short, are you telling me right now that despite what the school told her, the kids have been doing their online classes with Paragon?
Yeah. Yes. I am telling you that.
All right. So here's what I'm going to do. Mr. Short, I want you to raise your right hand, please. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
So how many children are enrolled right now at Paragon?
They're currently all 4, but I only get the 3 that come here with me, so 4.
Okay. So the 3 that I'm concerned with here does not include, I'm sorry, what's the child who doesn't come to you?
Keegan,
okay. So all of the other 3 children have been completing all of their online classes at Paragon the entire time they've been with you this week.
Yes.
Okay? Ms. Hughes, raise your right hand, please. That's your left hand, I think. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yep.
Is it your testimony that Paragon School has informed you that the 3 children that are with Mr. Short are not participating in their online schooling at Paragon since they've been with Mr. Short?
That is correct.
All right, so here's what I want you to do, ma'am. I want you to go to Paragon. I want you to get something in writing from them signed by a principal or each of their teachers addressing whether or not they have done that. I want you to submit it to the court. I want you to submit a copy to Mr. Short, and we'll get to the bottom of this. I expect them to be enrolled and participating. If they are not, and I find out they're not, somebody's going to pay for lying to the court. Now,
I actually have a picture of Turner's report online, and it shows none of his work being done right now.
just do what I told you to do, ma'am.
Okay.
So I'm trying to figure out the best way to make up parenting time with Turner. On what day did the exchanges take place?
Sunday.
Sundays? So if Turner were to come on a Saturday instead of on a Sunday, would that work to make up this parenting time that was denied?
Sure.
Sure.
All right, so we're talking 21 days that you were denied. So 21 Saturdays, Turner needs to come on Saturday to make up the denied parenting time. I will issue an order to that effect.
What time would we do pickups on Saturday, considering Sunday pickups are at 6 p.m.?
Same time.
Okay.
Okay, that concludes our hearing. Thank you. All right, we'll have to talk about this one, Peter. Okay, next up is Stepp versus Ellis. Mr. Ellis is present. And Ms. Stepp, can you hear me?
Yes, I can hear you.
Okay, so we're here this morning on your objections to the recommended child support order. You're not objecting to the first order, which is effective January 3 of 2020, but you are objecting to the order that takes effect August 1 of 2020.
Correct.
Based upon, it looks like they've got Mr. Ellis calculated as receiving only $696 per month in gross income. I'm not sure how that was arrived at. Mr. Ellis, are you currently collecting unemployment?
Yes, sir, I am. I'll actually be starting with my new, this will be my last week of unemployment. I'll be starting next week with my new company. So,
I have I have trouble believing you're only getting $696 a month in unemployment. That doesn't, with all the extra incentives around, that doesn't sound accurate.
Okay, let me explain it to you then, sir.
Is there any way you could turn, Mr. Ellis?
Yeah.
Can you adjust your volume at that end? You're barely coming through.
Can you hear me now?
I can barely hear you. I can turn up the volume at this end, but it's going to mean that Mrs. Stepp is going to be really loud.
Oh boy. Can you hear me?
Hey, that is much better. Thank you. Go ahead.
Okay, so no. So when I started work last August of last year. So when the pandemic occurred, at that point I did not have enough earnings for the full year to get regular state assistance. So I fell under the federal pandemic assistance, which was $600 a week plus 160, so that totaled to be $760 a week. That ran out a couple months ago when the federal unemployment, the $600 a week ran out.
So you got $760 a week from August of last year? No, that can't be right.
No, it would have been from the end of March of this year up until August 1st would be the exact date is when the federal ran out. So it would have been, would have been March to August.
All right, and then you're currently not working, but you're still getting some unemployment?
Well, currently right now the unemployment is at 160 a week, which is, 320 biweekly, but she gets half that. So right now I've only been getting 180 every 2 weeks.
Right, but the gross amount that you get is 160 a week?
That is correct.
But you're due to start a new job when?
Monday.
Oh, okay. Do you know what your earnings will be at the new job?
I don't know. I'll know more tomorrow on that.
What's the name of the employer?
Tower Automotive, and that's in Elkton, Michigan.
All right. So what I'm going to do is direct the friend of the court to follow up and make sure we get current wage information.
Sure.
Ms. Ellis, the other objection, you said there isn't anything that talks about his arrearage, but arrearages are collected separate from current child support orders. Those, if there is an arrearage, what they do is they essentially do a wage assignment for whatever the maximum is that they can in order to chip away at the arrearage. It's just handled separately.
Sure. Your Honor, I just have a question for you if you got a second.
Make it quick.
Okay, so I contacted a friend of the court, and I brought my concerns up to the referee last time I was in there, and Miss Stepp, I had showed her the same paperwork. So we agreed on the 390 something a month. That was done in front of you. So how does this referee go and change it to 1,100 a month and retro back it all the way to January when I haven't missed a child support payment? The problem with that is, sir, I'm being charged 1,100 a month. And she went all the way back to January of last year, charging me $250 a month for my son, who's been living with me since December of 2019. So her whole calculations here are 100% incorrect. And I tried to bring that up to her, and she wasn't trying to hear it. So my balance on my arrears went from $7,000 to $13,000 because all that money is in there for my son. When he's been here, he graduated from high school up here. He's been with me since December of 19. And I tried to bring it up to her several times. She told me she didn't have time for it. She wasn't trying to hear it. Also, I'm looking on the thing here, and I've been being charged medical expenses for him since January of 2020. 2020. I pay $146 a week for his Blue Cross Blue Shield on my plan through work. So there's thousands of dollars here that went into arrears that should not be there. Problem with that is the police were here 2 weeks ago with the Attorney General Mind you, I haven't missed a payment in over a year with a felony warrant for my arrest.
That's surprising.
Very, very surprising. I haven't
Because
missed a
normally
payment.
they don't.
And
Normally
I did
they
work
don't.
it out with them. I worked it out with them, so we agreed. We agreed I'm gonna pay them $500 a month on top of the current support. I have no problem with that. And me and Miss Step, we have been talking lately. It's been good. We did agree upon, me and her, to get set in motion today, $50 a week in current support for the first 3 months. After 3 months, we will go up to $100 a week for me. Me and her are both in agreements on that.
Ms. Depp, are you in agreement with that?
Yes. So what we came up with an agreement is, and just to let you know, the back child support is actually, it dates back 4 years ago. So yes, he is correct. In the last year, he has made a payment every month on time, but the arrears added up because for 3 years prior to that, there was no child support. So what we've agreed upon is the Attorney General wants him to pay $500 a month for back child support. And then what we agreed upon is $200, or if you want to look at it as $50 a week, it equals $200 a month. And we're going to do that for 3 months for the current amount. And then after the 3 months, we are upping it to $400 a month or $100 a week, if you want to look at it that way.
And if you're both in agreement with that, I can put together a support order that reflects that. But Mr. Ellis is still complaining about whatever extra arrearage got added as a result of this order that dates back to January. Do you have any agreement on? Do you have any agreement on that?
Yeah, looking at the paperwork, it looks like it needs to be reviewed. It looks like she did charge him for Russell living with him from January until May, which he should have been taken off in May because he graduated. And so basically it needs to be redone to reflect that he had one child from January until May because he's taken off after May. And then I had the 3 children. So it does need to be reviewed. It does look like they were charging him child support for the time that he was living with him. And also after the fact that he's graduated in May.
Yeah, Your Honor, they stopped the child support in June of this year, but this doesn't go back to, I don't think it's fair to me that this just gets, taken care of from May. Like I said, he's been here since December of 2019. I paid his $146 for his medical insurance every month or every week. That's a week. And so basically,
But
they're charging.
Let me, Mr. Ellis, we cannot retroactively adjust child support unless there is an order or motion or something filed. We can go back to whenever the motion is filed, but we can't go back any earlier than that. It's prohibited. So if there's something prior to January, I can't fix that, but I can fix from January forward.
Oh, from January of 2020 till now, right?
Yes.
Okay, I'm happy with that. Yeah.
That was the effective date of the order you're objecting to. All right. Well, I will direct that back to the friend of the court. I will reflect the agreement that you all made, that it should be reflected in the child support order. The one, so Mr. Ellis, you made a point about being charged with medical when in fact you've been paying for medical insurance.
Yeah, that's correct. I understand. I got to pay towards the state for the other 3 that are living with her for their Medicaid or whatever. I have no problem with that. But they have Russ included in the calculation dating all the way back to January of last year or this year also. And I just don't think that's fair to double dip like that. If I'm paying Blue Cross Blue Shield 146 a week on this end, to also be paying the state of Michigan when he's in my care.
Okay, and normally, the child support calculation will take into account what you're paying out of pocket for medical insurance and gives you a credit for that.
Right.
And I'll make sure they review the whole thing. How's that?
Okay, sounds
Your
good.
Honor.
Like I said, go ahead.
Yes.
I just
Go ahead,
wanted to
ma'am.
bring one. Yep, I just wanted to bring one thing up. I do think that they did do the credit, Russ, but there is one thing. When you stopped working and were receiving unemployment, which I think was March of this year, if correct me if I'm wrong, but you were not paying on the insurance after you had gotten laid off. Is that correct?
No, I still to this day pay on the insurance.
Okay.
Like the company, they've agreed to split it with me, which I have documentation all the way until January of next year. So they're paying like 60% and I pay 40%.
Okay, and just so you guys both know, all the children, even Russell, who is obviously 18, almost 19 now, and off child support, he is still covered under my insurance as well, which is Blue Cross Blue Shield as well.
We had him
Okay,
at the doctor the other day, and he has no current insurance except for mine.
So I'm pleased to hear that the two of you are talking and that you've been able to work out at least the child support stuff. Yeah. There's some pending parenting time, and Mr. Ellis, I think the last time you were in front of me, you said you were getting ready to file a custody motion. Are those things that you're talking about as well?
Yeah, that's the thing, Your Honor. If I can keep the lawyer out of it, and if we can, like I said, there's been a lot more dialogue. It's been good. If we can work it out between us, I'd rather go that route. It's easier for me.
Tell you what,
for everybody. It's easier for everybody.
I absolutely, if you two can agree, it's ideal, not only for you and saving attorney expenses, it's ideal for your children. If the two of you can agree on things. So what I'll do is we'll just hold off scheduling any kind of a hearing regarding custody or parenting time until one of the other of you says it's not working, we need the court's involvement. How's that?
Sounds good to me.
Okay, very good. I'll enter an order to that effect as well. All right, thank you very much. Have a good day, both of you.
Thank you, you too.
That is indeed good news.
Why can't they all just get
All right, this is one that's going to take some work. Go up to talk about that one. All right, let's see. How we doing? Next up is Simpson versus Pennell. Neither one of those appeared, but there's a note on the file, Shannon, that there was no proof of service regarding the motion to terminate.
Okay, do you need me to do an order?
No, because I think this may come back up once they're able to get service. It'll probably just get renoticed. All right. Next one, Bradshaw versus Eubanks. Looks like this. Oh, Mr. Bradshaw is present. Or actually, I don't know if it's a. Oh, it's a child.
Okay.
Okay, this is a matter of Bradshaw versus Eubanks. So Ms. Yanessa Eubanks is present, but we don't have an audio connection. And Samuel Bradshaw is present, and I'm assuming,
Yes, sir. It's with my daughter, Samari Bradshaw, and then with her mom.
well, yeah, wait a minute, hold on. So were you appointed next friend?
No, that's my daughter's mom was appointed.
Brianna Johnson?
Correct.
Is she present? Oh, okay, come on forward. She's in the courtroom.
Okay.
I gotta interrupt for 1 second because I'm totally confused. Are we doing the Bradshaw versus Eubanks PPO or the Johnson versus Bradshaw show cause in the DS case?
I called the PPO case. Is there another? Come on forward, ma'am.
I'm getting the Bradshaws mixed up here.
I've not called I don't care where you sit, ma'am, that's fine. I didn't notice. Okay, so Mr. Bradshaw, you're here on the Johnson versus Bradshaw matter, correct?
Yeah, there is the PPO was before mine that I have against Brianna Johnson. I have a show cause for Brianna Johnson, but before my court hearing, she has a PPO for my daughter for Yanessa Eubanks.
Okay, so I'm going to deal with the PPO first.
Got it.
All right, so the child involved here is Samari Bradshaw. That's your child?
Yes, there's actually 3 children involved.
Well, I only see one child on this.
There were 2 separate PPOs.
The only one that's in front of me today, well, let me make sure.
I'm sure it is.
Well, ma'am, I don't see how you could be sure.
Because we've already been in front of you for the other one.
The only one in front of me today is, oh, wait a minute, hold on. Yeah, is Samari Bradshaw versus Yanessa Eubanks. That's the only one in front of me today.
Correct.
That's all I was trying to say. All right, so you were appointed as next friend on behalf of your child. And Ms. Eubanks filed an objection to the PPO. So what I need to do is to take testimony from you, first of all, to establish that there is a basis for this PPO to continue, okay? Would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your full name for the record.
Brianna K. Johnson.
Ms. Johnson, you have a child, Samari Bradshaw, age 12?
Yes.
All right. And what, if any, relationship do you have with Yanessa Eubanks?
She is Samari's dad's live-in girlfriend.
Samari, and is Mr. Samuel Bradshaw Samari's dad?
Yes.
Okay. All right, so hold on. But what is it that Ms. Eubanks has done or said that you believe requires the court to keep a PPO in place?
That back in June of 2020, Vanessa abused my youngest child and Samari,
When you say abuse, could you be a little more specific?
she beat him with Samuel's steel toe work boot and a belt.
And what's that child's name?
Cassidy Bradshaw, she has current abuse charges for this.
Okay.
And immediately after that, I took him to the ER because he needed his arm x-ray and CPS was involved. There's been ongoing CPS and there was a no contact safety plan put in place then.
Right, but my understanding from the last time one of these files was in front of me is that the safety plan has been lifted.
Correct, with the dad. From Samuel Bradshaw, not Yanessa. Yanessa's the abuser.
Is there still a safety plan that requires the children not be exposed to her?
I'm not sure what the newest one says. He had one that I have never seen from a different CPS worker.
Well, typically what would happen if there's a CPS investigation, that there is some verification that abuse or neglect has occurred, but it was by someone else who lived in the house, not the parent.
Right.
The safety plan would typically require the parent to keep the child from whoever it was that was accused of the abuse.
Right.
There wouldn't have been any other safety plan in place other than that. And if that safety plan has been lifted, that would tell me that CPS has decided there's no longer any danger.
The reason that they had decided that is because the kids had still been in my custody. The kids had still been with me, so ongoing CPS wasn't able to do any other investigations in the home because the kids weren't there. Mia.
That doesn't make sense to me.
That's
They would, just because the children are in your care doesn't mean they would lift the safety plan if there's a parenting time order or custody order that says that dad is entitled to custody or parenting time.
Correct. I'm saying that that's why CPS closed the case. That's why I don't even know if it's been closed completely, but that's why they were wanting to close the case, because the kids were not with Mr. Bradshaw, that they've been with me.
That might be why they wouldn't file a neglect case, but that isn't a reason to lift the safety plan. So that part doesn't make any sense to me, ma'am. Let me look at that other file and see.
Your Honor, if I can chime in.
Yeah, give me just a second, sir. I want to see if there's something in place. All right. I will hear from you, sir, but not yet.
Okay.
So the reason for this PPO initially was because of a complaint of abuse by Yanessa against one of your other children, correct?
And Samari, she was calling the school and posing as myself, and because my kids are doing the online virtual schooling, the principal recognized that she wasn't the mom, and she called me to let me know that she had been posing as myself to use Samari's phone book. And so Samari wasn't able to do schooling, and she was also changing everything online. She was messaging her through the whole CPS thing, telling her what to say to the CPS workers, and contacting her on social medias, text messages.
Wait. Who's contacting whom?
Yanessa is contacting Samari. That was the whole cause for all of the PPO, or the 2 PPOs in the beginning. I know you said you don't have the other one. I apologize for bringing that one up again.
So she was contacting Samari, trying to influence what she was telling to CPS?
Yes.
And she was also contacting the school posing as you.
Correct.
Which the school obviously recognized.
Yes.
And didn't do whatever it was she was trying to get them to do.
They did at first. until they realized it didn't make sense. And then the 8th grade principal got involved, and then Samari's principal was involved. And
So you
it's been
want,
straightened out now.
you want the PPO to prohibit her from contacting the school regarding Samari?
That and abusing yes. Yes.
I can certainly have a PPO that keeps her from abusing children. That's pretty easy. But I thought you wanted this PPO to keep her from even having any contact with the
I
children.
do, absolutely. But all 3 children, this case is only about Samari.
All right. Any other reason you think a PPO needs to be in place as to Samari?
Just that the evidence has been substantiated and she just hasn't been in front of a judge yet. That's literally the only thing that's holding this up. I can't think of
Well,
anything else.
has she been criminally charged with
Yes.
child abuse?
Yes.
Okay. Was there actual physical abuse of Samari?
In the past, yes, but not this case, not this specifically, but in the past, yes. And she was also interviewed at the Child Advocacy Center and can show you that as well.
Okay. So I think I have a good sense of that. Let me hear from Ms. Eubanks. Ms. Eubanks, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your full name for the record.
Yanessa Eubanks.
All right, so you acknowledge you are the girlfriend of Samuel Bradshaw, Samari's father?
Yes.
Okay. And do you also acknowledge that there's at least has been and might still be some kind of open investigation or prosecution for physical abuse on Mr. Bradshaw's children?
No, she said no. That's not true at all. She's saying there's been past abuse with Cassidy, Ayana, and Samari. I have a full statement and police report. What she is stating is absolutely false. Was the allegations brought up? Have I been dealing with CPS? That is true. But everything that CPS has asked me to do, I have done it, and our case has been closed. The only reason that it did stay open as long as it has is because Brianna has not been cooperating with CPS. And she's been the only reason our case has been held up. I have did the completion of having family first in our home. Me and Samuel did all of that was asked of us, and everything was dropped. And when it came to the schooling, what she is stating is completely false. When it comes to the kids going to school, Samuel has put me on the paperwork because I'm the only one he can depend on when it comes to the kids. Because I have always dealt with it. I have did the teacher parent conferences. I go to any and everything because Brianna will absolutely not show up at all. I have never touched none of her children. And also in the report, she also stated she took Samari's cell phone because she was communicating with me. What she's stating to you is completely false. I have all the paperwork. And Samuel Bradshaw can speak for himself as in giving me permission to handle the kids' schooling. I have always done it for the past 3 years, me and him alone.
And I do have the letter from the prosecuting attorney's office showing that what I'm saying is true. I also have the text messages if you'd like to see any of those.
Text messages from who?
Samuel Bradshaw and between Yanessa and my daughter. Samari Bradshaw.
Regarding what she should be saying or
Right.
not saying to CPS?
Well, that too, as well, yes. But there's proof I'm not sure why she's saying she's not being charged with it. You can look it up. She has several abuse charges.
Oh, he can. Oh, sir, you can look into our report. Like I said, the allegations were made, but what she's stating to you is absolutely not true at all. Not true at all. I have never done anything to her kids, not one time, not ever.
Investigations alone would prove that's not true.
I'm not too sure, Judge. Do you have the evidence that I have submitted to the courts in front of you?
I'm looking through this. I see a letter from Catholic Social Services thanking you for participating in the Family's First program. Which it looks like you successfully completed.
Yes.
I've got a bunch of text messages going back to 2017.
Yes, because that's when it started with her. This is the woman sitting in front of you is the one who threatened harm against me, my children, death threats. She has done it and said it all. I have never done anything to her.
And I'm not denying any of what she's saying that we haven't gotten along, but the fact is that my children are being abused in her care, and if they go back to their dad's house and are left alone with her, then that's giving them the chance to do that yet again. This has been going on for years. Yes, it started with her trying to discipline my children, was starting with popping them, and then she was leaving marks. And Samuel and I had conversations about this, that I was not okay with her disciplining the kids. It stopped for a while. Samari got a little bit older and she stopped hitting her. And then Ayana started getting to where she was telling Yanessa, telling her what happened. And so she stopped hitting her, but she's still continuing to hit Cass. And when my 6-year-old daughter is telling me that she's so scared Cass is getting hurt because Yanessa is beating him in behind the door and hitting him with daddy's boot, and she knows it hurts because it's the big one. Like, those are not things that
Your Honor, the evidence is also in front of you. What she's stating is not true. If I was harming her children, why would she
Hold on. I can't have two people talking at once. I can't hear either one of you. So, Ms. Eubanks, go ahead.
Yeah, what she is stating is false. That's why I turned in all that evidence. Her own kids didn't want to stay with her. I even turned in proof while she's saying that I'm abusing them. She would bring them back to me because they would cry all night and not want to be with her. Those is Brianna on words that she texts. She always bring the kids back to me.
And I think what she's talking about is a running joke that her dad and I have. That must be his text messages.
No, sir.
I've never even contacted Yanessa.
She wouldn't even call me at work. Not true.
She is lying.
Okay, before I make any decision on that, I also have a show cause in the Johnson versus Bradshaw matter, which appears to be related. And this was based on Mr. Bradshaw's complaint, ma'am, that you are refusing to comply with an order of this court. Trying to find the year or the date of that order. Well, let me just ask you, Mr. Bradshaw, I want to hear from you now. I had to mute you because there was some noise coming through, feedback or something.
Yeah, we was
Mr. Bradshaw,
sitting in this. Oh, I'm sorry.
Raise your right hand, please. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your full name.
Samuel Bradshaw, second.
So, Mr. Bradshaw, you asked the court to issue an order to show cause because of Ms. Johnson refusal to return the children to you.
Correct.
And forgive me for not having it readily available. Usually somebody tabs these things for me. What does the current custody and parenting time order say?
I have sole physical custody of the kids, and there is no parenting time for Brianna Johnson, as I say, as I states. You did put in a motion for us to have parenting time, custody, and child support, in which I know you probably don't remember. Brianna stated that she filed a motion for parenting time, which she never had. So you went ahead and done it. So we have court on November 3rd with a referee.
All right, to address what the custody and parenting time should be going forward.
Correct.
But in the interim, the current order that's in place says you have sole physical custody.
Correct.
And where are the children now?
There's a lot of things I didn't say in the first hearing, but since going through the CPS and the safety plan was lifted, communication with me and Brianna, she is refusing to tell me where the kids are. I had police go to the latest address that I have, or that we have on file. That house is vacant and has a for sale sign in the front of the house. I haven't seen my kids.
Hold on. I wasn't asking you what address they were at. You're saying the children have remained with Ms. Johnson in her care ever since the safety plan was initiated.
Correct.
Okay. And since the safety plan was lifted, she's not returned the children to you.
Correct.
Hold on a minute. Okay, and ma'am, you acknowledge the children have not been returned to Mr. Bradshaw?
That they've not been physically returned, yes, but I have offered for him to meet at a park. I've offered for them to do Zoom meetings. I do have the messages to prove that. I also have the messages to prove that my daughter, up until the no contact order, was messaging him every single day, trying to get him to respond, asking him how his day was. That my kids have been trying to be in contact with Mr. Bradshaw. But again, like Inessa just was lying. He's doing that, I don't know, maybe to save face here. I'm not sure. But I can prove all of that to you today. I have that.
Mr. Bradshaw, have you had contact with your children?
Not physically. I maybe talked to my oldest daughter 4 times through text message. I would get text messages at 10 or 11 o'clock at night, and when I will call, there will be no answer. And the text messages are random. So I know it's Brianna Johnson that is sending me the text message to say that it's my daughter's texting me. It doesn't make sense. If you text me and I
Have
call, why
you
don't you pick up?
have you actually had a conversation with any of your children?
No, not at all. And then for her to say that she'll let me see the kids at the park, that had never happened. For her to say that we can do a Zoom meeting over the phone, that had never happened. I don't know where my kids is, sir. And right now, with the evidence that I have, she is facing charges for parental kidnapping. She has a warrant out for her arrest.
So you have no way of contacting any of your children to have a conversation with them? Is that
No,
what you're telling me?
correct. No, sir. My oldest daughter had a cell phone, and when the CPS investigation, when it was lifted, she took away my daughter's cell phone. So I have not talked to the two littlest ones, and the last time I talked to my oldest daughter, she was crying on the phone that she missed us and she wanted to come home. I don't know why she was putting my daughter through this, putting our kids through this. She's being selfish. She's only thinking of herself. Um, to get in depth, I believe it's over jealousy of how happy our kids are at home. She's not keeping the kids away from us because they're in danger. She's afraid of when the kids come home and CPS are able to see how the kids react with Yanessa, then they will look at Brianna and notice that she has been lying and that this whole CPS case was staged. And like she just stated that supposedly Yanessa had hurt my son. She waited 24 hours to send him to the hospital. And she sent me a text message asking me, do I want to come to the hospital? She think Cash broke his wrist. I said, okay. Even then, she never said anything about the allegations that is point in front of you of what you said about my son being beat with a steel-toe boot and a belt. And like I showed CPS, there's only one pair of steel-toe boots, and I wear those to work. So those wasn't even in the house. And I have cameras in my home. The belt that she's referring to, you can see it on the camera, hasn't been moved. And when I was talking to the CPS worker, she wasn't concerned about those two items.
So how old are the children involved here?
4, 6, and 12. Oh, and I also want to state that she's saying that Yanessa was pretending to be her for the schooling. She never had to pretend to be her on file. She's on family and friend. Brianna Johnson hasn't been involved since the 3 years that I had the kids. The help that I did have for my kids having perfect attendance was from Yanessa helping me. The mother, Brianna, has been unreliable for the past 3 years. If you call the secretary at Northeast, she would tell you that she doesn't know Brianna until this year. She only know me and Yanessa. And again, there's no reason to say that Yanessa is the kid's mom. That I don't even know why she say that when we have the emergency contact on paperwork showing where Yanessa puts her name, as family friends. I don't even know why she states that.
All right, so here's what I'm going to do, folks. I'm going to take both of these under advisement. That means I'm not making a decision today, but I'm going to appoint a lawyer guardian ad litem to represent the best interest of the children. That attorney will get a hold of both of you. That attorney will meet with each of the children privately. That attorney will meet with, and then will issue a report to me that will help me get to the bottom of this. Clearly, I'm hearing two completely different stories. I want to get to the bottom of it as quickly as possible. If I find that anyone has been unreasonably refusing to follow my orders, there will be consequences for that.
And sir, can I just add that we had court already, and you told her to return the 2 minor kids, and she still has not done that?
I understand that. I want to hear
Okay.
from the lawyer
Okay.
guardian ad litem.
Okay. And I did say to the caseworker that You know, she is good at coaching the kids to say whatever. That my kids don't want to, how to put it, hurt either one of our feelings. So I did suggest to the caseworker, to the kids, to go to a mutual party so Brianna Johnson doesn't have any influence on the kids.
This LGAL will interview the children privately, and will do a good job of making sure that it's the children's statements that are being heard, not what they're being told to say.
Okay.
So, Your Honor, I do have a question.
Yes, ma'am.
In June of 2018, we came in front of you and we had, our custody order was joint legal. At that time, I was obtaining my CDLA, so I was gonna be over the road. That is what Mr. Bradshaw was referring to earlier. In that time, my address changed and we were still able to communicate and still have a schedule for me to see the kids when I was on my home time. But yes, their physical address changed, which is why we came in front of you to stop his child support, because they were gonna be with him more than they were gonna be with me. And then in that time, he let me have my back and knew that he was mailing the paperwork to the wrong address for myself, and he got a temporary full custody order, which is what he's talking about today. So will that be addressed in any of this?
We'll address everything.
Okay, thank you.
All right, you'll hear from the LGAL first, and then you'll hear again from me. Keep your current scheduled date as planned with the friend of the court.
Oh, the November 3rd?
Yes.
Okay, and then
unless you hear otherwise.
Okay, in the meantime, she is able to keep the kids. I still can't see the kids.
The current order says you should have the kids. If I find that it's being unreasonably disobeyed, there will be consequences.
Okay, I'm just curious if you can.
I hear you, but I want to hear from this LGAL. I'll make sure he gets on it as quickly as possible to try to get to the bottom of it. I want to make sure we have contact information for both of you. So, ma'am, I don't want you to put your phone number on the record, but if you could give your cell phone number to my court officer. And Mr. Bradshaw, I'm going to need your contact information again. Let me see if there's a number on the file. You filed a fee waiver request back on September 29th, and there's a cell number listed. Is that the correct number?
Yes, sir. You talking to me?
Yes.
Yes, at 395. Yes.
All right, we'll use that.
Okay, and then what I was asking to clarify, until you do your investigation, I won't see the kids until you have the final judgment. Is that correct?
I've got an order in place saying that you are to have the kids. If I find that order has been unreasonably disobeyed, I mean, I've already ordered it. That's what I'm telling you, sir.
Oh, okay. I want that to be clear because Brianna Johnson still has not returned the kids. So I just wanted to be clear for both of us.
That's very clear on the record, sir. I hear you loud and clear.
Okay. Can you ask her to give me the address? I can come pick the kids up. I don't know where my kids are.
Are you willing to allow the children to go back to him?
To him, yes, but not with the living girlfriend still being there. Absolutely not. I fear for the safety of all three of them going back there. No. Your Honor, specifically because I know once he goes to work, they will be left alone with her.
And you understand, if I find you've been unreasonable,
absolutely,
you're going to face consequences.
Yes.
I'm not going to issue any other order in that regard. All right, you'll be hearing from me shortly.
All right, and what you're saying is for her to still return the kids.
I'm telling you, that's what the current order says.
All right, because she just told you no.
I understand, and she's been informed of what the consequences will be if I find out that refusal is unreasonable.
All right, so if I don't get the kids today, I can file a motion tomorrow for show cause.
You don't need to file another motion, sir. It won't do any good.
Okay.
I'm addressing your motion by what I've said I'm going to do today. Okay?
Okay. Thank you.
And the LJL is going to get appointed. I'm going to get some firsthand accounts of what's going on. I'll make decisions after I get that report.
Okay.
All right, that concludes our hearing.
All right, thank you.
You're free to leave, ma'am. Okay, next up is Bollinger versus Nemitz. I had Erica Bollinger in the court hearing at least an hour and a half ago. She's disappeared. I don't know what happened. Perhaps she ran out of time. I'm going to try to get her on the telephone number that's listed on the paperwork. So Shannon, Carol Nemitz is present.
Thank you.
You have reached the voicemail box of 517-879-6704.
Ms. Bollinger, this is Judge LaFlamme. We had a hearing scheduled this morning on your request for issuance of a PPO. I do recall that you had logged in much earlier today. I'm assuming, based on the length of my docket this morning, that work responsibilities or other things have taken you away. Obviously, I can't issue a PPO if I don't have you present. If you wish to renew, you can contact the court and ask them to schedule another hearing. Make sure Ms. Nemitz gets a copy of that, but in the meantime, no PPO can be issued. Have a good day. All right, Ms. Nemitz, I won't be able to take any action unless she renews her request for a hearing. I don't really need to hear from you. I'm not going to do anything today.
Okay.
Save it for if we have another hearing.
Okay, thank you very much.
You're welcome.
Is there an order in there, Your Honor?
There's not.
I'll just use one really quick right now.
Make sure you put in it that she may re-notice her motion. I suspect that's what happened, because she was definitely here earlier. All right, let's see. Hey, I think I can close this here.